Yes, thank you very much. Welcome, and make yourself comfortable.
Thank you.
You have been here not long ago.
Yes, my lady.
Yes, so
Thank
we'll still do a round of introduction for the sake of the record.
Yes, ma'am.
My name is Martha Kome. I'm the chairperson of the Judicial Service Commission, and I welcome you for this interview.
Thank you, my lady.
Good morning.
Good morning.
Name's Isaac Ruto, also Vice Chair.
Thank you.
Good afternoon, my Lord. Jacqueline Ngutia, Commissioner, welcome.
Good morning and thank you.
Good afternoon, Justice Katwa. My name is Caroline Lani. You're welcome.
Thank you and good afternoon too.
Good afternoon, Judge. My name is Charity Kisotu, a Commissioner. You are welcome.
Thank you very much.
Good afternoon, Judge. Omwanza Mbati, karibu.
Thank you and good afternoon.
Good afternoon. I'm Joaquin Dongo, representative of the Supreme Court on the Commission.
Thank you.
Good afternoon, Judge.
Good afternoon, my
Anthony Mrima. Welcome and I wish you the best.
Thank you very much.
Good afternoon, Justice Kigen.
Good afternoon.
Fatuma Sichale, I'm your representative at the Commission. Karibu sana.
Thank you very much.
Good afternoon, Judge.
Good afternoon.
You're welcome. My name is Oluwande Evelyn.
Thank you.
Good afternoon, Judge. Dorcas Odor, Senior Counsel and Attorney General. Welcome.
Thank you very much, Commissioners. Judge Joseph Kipchumba Kigen Katwa.
Yes, my lady.
Could you tell us your county and your ethnicity?
My county is Elgeyo Marakwet and my ethnicity is Keyo.
Very well. Do you know why we ask that intrusive question?
I do, my lady.
Why?
I think for regional balancing and basically regional balancing, I think.
Is it a constitutional imperative?
Yes.
Which particular article?
I can't quite place my finger on the exact article, but I would say it is intended by Article 10, Article 7283, and Article 236.
Yes, very well. So now we will start. You were here not long ago, and I think the challenges I have is what questions to ask you, because we recently interviewed you successfully for the judge of the Court of Appeal, and you have hardly been there for 3 months. You under normal human HR practice, human resource practice, at least one stays in a job for 6 months to be evaluated for promotion. You haven't been there for even 6 months for promotion. So maybe you can explain this before we go to the questions.
Yes, my lady. I know that you very particularly mentioned the point that I haven't been there for more than 3 months, and that in an ideal environment, I should have waited for a little more time so that there is perimeters for my evaluation for promotion. My lady and commissioners, my understanding of why I am here is different from that. My understanding is that I've come here for evaluation as to whether or not I'm eligible for appointment to the Supreme Court. And that eligibility is not a question of promotion, it's a question of whether I'm qualified. And when I looked at the scoping that was done for a person who can qualify for that office, I thought I met the conditions, and in the circumstances I applied. So, Chair and Commissioners, I'm here very humbly seeking that I be evaluated on my competence to be appointed. And the fact that I may have recently been before you should not be a factor, because I'm not here for a promotion. I'm here for whether I'm competent. I also observed that quite a number of people have come to the Supreme Court directly from outside judiciary. And so judiciary is not necessarily a stepping stone for qualification to qualify for that office. Those are the considerations that were in my mind, Chair and Commissioners. And I say this with the greatest humility.
Mm-hmm. Very well. Now, then we can come back and forth to that question of, are you happy in the Court of Appeal? Are you satisfied with being a judge in the Court of Appeal?
I am, my lady and commissioners, and thank you very much for having found me deserving to take up that office. I want to express my gratitude to all of you.
Mm-hmm.
Yes.
Yes. So now, we want to hear from you why you think this commission should recommend you for nomination of the office of a judge of the Supreme Court. We want to hear what experiences and skills and knowledge you will bring to this court, and how you're going to leverage them or to locate these skills within the 5 or so jurisdictions of the Supreme Court.
Thank you, Chair and Commissioners. I consider myself eligible for consideration to the office of Supreme Court Judge on the premises that, in my estimation, I have a feel and experience of all facets of Kenyan, both as a Kenyan citizen and also my competence in legal practice. I grew up in an environment where, in an environment of want, I went to Kiplombe Primary School, I went to Mother of Apostles Seminary, I then went to St. Patrick's High School, then came to Nairobi University, and through all those levels, it was hard work, enterprise, and studies that took me through all that. I then entered into legal profession now for about 30 years, and I have both national and international experiences. I have represented all cadres of people. I have gone to all legal forums and even non-legal forums, and the wealth of all those experiences, my lady and commissioners, are such that I would contend that makes me very qualified for this. A little more on the issues of where I've appeared. I appeared in tribunals, I appeared before commissions, I appeared before magistrates all the way to the Supreme Court. I have represented judges, I have represented advocates, I have represented other people. I mentioned particularly representing advocates and judges just to make the point that those are the best judges of my competence, and if in their evaluation they thought I could represent them, then it is a strong statement of my competence. I think the type of works I have done, the results I have produced, are such that they also strongly comment on my competence. I will not pretend to know all the law, both in terms of statutes or precedents. I will not pretend. But what I can say for a fact is that I have the competence to identify what the issues are, to be able to analyze them, to be able to research and familiarize myself with what I need to determine. And this is born out of experience. I have represented people outside the country where I've had to learn other legal regimes and systems, and particularly the confluence of common law and civil law at the ICC. I have had to study and analyze the operations of sports law and represented athletes on sports law. And the legal regime, I appeared even long before the legal statutes were quite in place in Kenya. And so there was near vacuum on what we need to look out for. And it was through my research and enterprise that I was able to familiarize myself and be able to represent them. I have also appeared in the East African Court in Arusha, and that required of me to look beyond the statutes that apply in Kenya, to look at the statutes that apply in East Africa and internationally. And the accumulation of all those experiences, my lady and commissioners, are such that I contend that I'm in a position to be of service to the judiciary at the level of the Supreme Court.
Thank you very much. We will now move on to another area, and Justice Ishale will take it from here.
Thank you, Honorable Chief Justice. Judge Kigen, there are concerns expressed by a section of Kenyans.
Yes.
As regards your suitability for the position of a Supreme Court judge.
Yes.
And these concerns were made known to us as the Judicial Service Commission via a letter dated 8th of April 2026, which we have since brought it to your attention. Did you get that letter?
No.
Oh, I'm sorry.
No, I'm hearing it for the first time. But I suspect I know what it could say. Probably just say it.
Okay. Let me just bring to your attention what
Yes.
the section of Kenyans are saying. They're expressing their misgivings about your candidature. Firstly, they are concerned over the fact that you've been a lawyer for His Excellency President William Ruto, and who is likely to be a candidate in the elections of 2027. The fear that these Kenyans have is that in the event that you're successful and you join the 6 judges in the Supreme Court, and then thereafter there is a petition challenging presidential elections for the year 2027, their fear is that you are likely not to be impartial. What do you have to say to this?
Okay, so first of all, it is true I have represented him. May I say that I intend to be as objective and neutral in my discharge of my functions as a judge. And so the fear is, well, I can't say it is ill-informed. I can understand the concerns, but I just want to give the assurance that I would be fair and I would only deal with facts and the law. I would also like to say 2 other things, commissioners. The first one is I am aware that that concern has been, and that's why I was saying I have suspicions that of what the letter is, and I must complain that you didn't share the letter with me so that I would have a more structured answer to the question. But let me just answer to this effect. That I have looked at the totality of judges, right from the High Court, Court of Appeal to Supreme Court. Looking at the totality of them, you would almost say about 50% of them were lawyers. And so for me to be told that you have a disadvantage because you represented a particular individual would be a borderline case of discrimination, because I would be being treated differently just because of the type of the client I represented, when in fact every other person who escalated to the status of a judge who was an advocate is not being subjected to the same disadvantage. And so, commissioners, with a lot of humility, I would pray that first of all, you look at me for what I stand for, integrity, fairness, and justice, and that I will apply the law fairly and objectively. But secondly, that to distinguish me just because of one client, a criteria that has not been applied to other candidates who applied to be judges, would probably not be quite fair. And lastly is that there are measures, if anybody is concerned about my sitting in the bench and as justifiable cause, there are provisions for how that can be handled, including recusal, and I'm aware that some presidential petitions have been done with less than the totality of the 7 Supreme Court judges. And the Supreme Court's workload is not focused or limited to only presidential petition. There are other work assignments that the Supreme Court has. And so if it were to be such a significant and weighty concern, I would say there is that option also for recusal. For all those reasons, commissioners, I pray that that should not be used to my disadvantage in this interview. I am glad to answer any specific issues that arise around that issue.
All right. I think we hear what you are saying.
Yes.
But you know, when it comes to the dispensation of justice, it is not important, it's not only important for justice to be done, but justice must also be seen to be done. And given the fact of the office in question, the stakes are extremely very high. And when you tell us, for instance, that there is that possibility that you can recuse yourself, and given that the number is only 7, and you know there are many things that happen in life, people fall sick, etc., etc. So if now we are saying we are going to take you, and then you've given us that undertaking that in the event that there is an objection to your hearing an election petition, presidential election petition, there is that possibility that you can recuse yourself. So what does that mean? That then, do we really even need to hire a 7th judge for the court? If we have the option of a recusal, right from the word go.
Can I proceed?
Pardon?
I can answer now.
Yes, please.
Okay. So, recusal is probably the bottom in the list, my lady. I would insist that I should be taken for what I say and what I have represented, being objective. My relationship with His Excellency is not such that I always said yes to everything he wanted or he wished for. And so it has never taken my objectivity away. But I understand your question to be more of the perception of third parties. So again, I want to say that the front line is to say that I should be taken for what I represent, that I intend to be objective and fair, and that that issue of recusal should be the last option. And even as I'm being put to task to answer that, I also want to insist that please take on board also the unfairness of the question and the unfairness of the concern just because of the person that I represented, a criteria that is not applied to other candidates.
All right. We just thought that it was important to bring to your attention what a section of the Kenyans are saying about your candidature.
I understand.
And you've given us your responses.
Yes.
The other concern, of course, was the fact that you've hardly been in the Court of Appeal, but I think you've discussed that in response to what the Chief Justice asked you. So now to my technical question. In a book entitled Cases That Changed Our Lives by one Ian McDougall, and in a scholarly article in that book, the scholar marvels at the wonders of the law, and I want to quote what he says: "Who would have ever thought that a partially decomposed snail in a ginger beer bottle would change the course of English legal history?" I'm sure you're aware of this case. A snail in a ginger beer bottle.
It doesn't come to mind immediately, my lady.
Wow. Because then my next question was going to be, yes, how did this case change the course of legal history in the countries that practice common law? Don't know you versus Stevenson?
Oh yeah, of course I know you versus Stevenson.
Yes. What was the law before the snail?
I know the law that was developed in that case being that whoever keeps an item that causes damage to injury to somebody else is responsible for the damage that follows.
I asked the question, what was the law before the snail? Keeping in mind the doctrine of the privity of contract. And if I may just remind you about the facts of that case, is that two ladies went to a cafe. One bought the two drinks, but Mrs. Donoghue was not the one who paid for the drink, and a snail was discovered in the bottle. And then the big question was, could she sue, and yet there was no privity of contract? She's not the one who had purchased the ginger ale. Are we together?
Yes.
Yes. So what was the law before then, and what is the law now?
My understanding of, okay, I can't say for a fact I know what the law was previously, but I suppose considering what the law then developed in that case must have been that it is a condition for you to claim damages that there is a privity of contract, that you have to have a relationship with the person you are suing. But then the consequence of that case was that if you are offering a product, it should be probably in more developed law now, consumer rights. If your items cause damage or injury to somebody else, the fact of lack of privity of contract is not a defense to your liability for what you're offering to third parties.
So that is the law after 1928, but before 1928, you had to establish that there was privity of contract. Now, coming back home to the Supreme Court, what are some of the notable jurisprudential decisions that you can say have impacted our lives?
How many, my lady?
Pardon?
How many?
Give me 4.
Okay. So I think the most remarkable ones for me are 2. The first one is BBI. And the issues then were whether, in the name of amendment, the executive could torpedo the Constitution, or could replace the Constitution in the name of amendment. And I thought judiciary came out very proudly there to firmly put down their foot and say, we can only change the Constitution using what is there. And I thought that was a very momentous
so that is one.
Yes,
one.
2.
Yes.
Is the 2017 elections, August 2017 elections, where the judiciary distinguished itself in refusing to recognize the presidential elections. I did not and do not agree with the reasoning of the court then, but I thought even then we shouldn't miss the point of the independence of the judiciary in making that decision. I thought it was a very momentous and strong statement of the independence of judiciary.
I agree with you.
Yes.
Number 3.
The third one from the Supreme Court would be the finance bill. For quite some time, I know there has been pull and push between the executive and judiciary, and it entails questions of whether the judiciary is being activist, is overreaching, and is micromanaging the executive. The concept developed in that finance bill, suspension of declaration of invalidity, is a very important measure, because then it gives the executive time to adjust itself to the requirements of the circumstances of the situation.
All right, and finally, the 4th one?
The fourth one is the Murwatetu one. Of course, it is very controversial, but then the determination that there has to be a distinction between the roles of the executive and the judiciary and the executive, the separation of powers was to me a very important.
Was that in Murwatetu 1 or Murwatetu 2?
In actually both, because in one, the decision I thought was a general statement that the judiciary should not seem to determine the sentence.
All right.
Should not tie it. But then in the Murwatetu 2, then the Supreme Court came back and said our intention was only limited to murder.
All right.
I think, yeah.
So it is like the issue of discretion, mandatory sentences.
Yes.
The executive should not interfere, but it should be left to the judiciary. Thank you. That's all, Honorable Chief Justice.
Thank you, Commissioner Mwansa.
Thank you, CJ. Good afternoon, Judge, again.
Good afternoon, Commissioner.
Judge, Article 19 of the Constitution is the article that starts with the rights and fundamental freedoms.
I'm allowed to refer?
Yes. And now, Article 19.3 provides that the rights and fundamental freedoms in the Bill of Rights belong to each individual and are not granted by the state. Then Article 19.3b provides that the rights and fundamental freedoms in the Bill of Rights do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are inconsistent with the chapter. And 3 provides that those rights are subject only to the limitations contemplated by the Constitution. Now, in developing that issue, we have what we call enumerated and unenumerated rights. And it could seem that what Article 19.3b states or provides for are what we would refer to as unenumerated rights. Now, while enumerated rights are clearly written, the unenumerated ones are inferred. So that the concept is that there is a limited list of rights in a constitution that does not mean that fundamental rights do not exist. So the first question is as follows. Are there rights that you would say that are fundamental and are not contained in Chapter 4 of the Bill of Rights, but they are unenumerated and you can infer them? And if so, if you probably can list maybe 4 or 5.
Okay. Commissioner, I'm not sure I know I have an answer to the point you made about the enumeration. I'm not aware whether there is anywhere where they are listed, other than in the Constitution, of course, which I'm aware of. But I don't know whether they are somewhere else tabulated. Commissioners, I will pray to probably refer to the experiences I have. Some of the rights that I know are internationally recognized but are not captured in the Constitution is, for instance, against genocide. I am fairly sure it is not in the Constitution in the word genocide. I know there are issues of human dignity, human rights, against servitude and all that. But I think genocide as a crime is not there, and I'm borrowing from the International Criminal, the ICC statute. And I'm referring to the ICC Act because Kenya is a signatory, which in effect then, and most of the world countries are signatories, which then means it is a recognized right. So genocide, war crimes, acts of aggression. Others that come to my mind, and they do not necessarily even relate to Kenya, is apartheid. I think there is generally condemnation of conduct that amounts to apartheid, and I think that could be one of the rights that you could incorporate there. The upheavals in West Africa resulted also in warrants and summons on issues of damage to World Heritage Sites. And so I think UNESCO protected locations, or rather damage to World Heritage locations are also a crime. Commissioner, I hope I've managed to make 5. I'm not sure if I have.
Okay. Now, I want to go to Article 45, just to explore that topic.
Yes.
So, Article 45 of the Constitution provides that the family is the natural and fundamental unit of the society and the necessary basis of social order, and shall enjoy the recognition and protection of the state. And more importantly, Article 45(2) provides that every adult has a right to marry a person of the opposite sex on free consent of the parties. Now, when you read Article 27 on equality and freedom from discrimination, this is now the equality clause. It provides that every person is equal before the law and has a right and equal protection and equal benefit of the law. And then there is another important article, any ground including race, sex, pregnancy, marital status, leave. In the first draft of the Constitution, actually provided for discrimination against sexual orientation. But subsequently, in the discussions that followed and the final draft, excluded that reference. Now, if again you read Article 2(6) of the Constitution, it provides that any treaty or convention ratified by Kenya shall form part of Kenyan law under this Constitution. So I wanted to ask a question using that context. Now, Article 16 of CEDAW, the Convention Against Discrimination of Women, provides that a woman has a right to choose their partner. And the definition in Article 16 of CEDAW is different from the one that is found in 45. So the question is, if a party comes to court and pursues an argument that that article would allow maybe a same-sex marriage because it's a convention that forms part of Kenyan law, what would your view be about it? And would that be then what we started developing about an unenumerated right?
I can answer?
Yes.
Okay. So first of all, let me just add one more in the list I'd given. I've just remembered in the course of you inviting me to Article 45, I have remembered that Kenya now acknowledges for a fact that intersex people are entitled to rights.
Yes.
And that's not one of the rights of intersex and transgender. And I thought, even to the extent it is not enumerated, it is a consideration. I'm just concerned at what it says in 19.3b, that to the extent that it is not inconsistent with this chapter 4. Now, just on that issue of transgender and intersex, still, I have sometimes wondered whether the Supreme Court should be asked to determine whether the Constitution on its face, looking at it on its face, is wrong. Because at 45.2, I haven't answered your question, I know, but I'm just laying the ground.
Yes.
45.2 says every adult has the right to marry a person of the opposite sex. Now, what happens to the transgender and intersex people in Kenya whose existence we have acknowledged? Have they in effect been excluded by the Constitution? And probably more pointedly, and I think now this comes to the question you're asking me, is if two intersex or two transgender people come and say they want to marry, and the courts have determined that they are entitled to rights, are they then to be denied the right to marry using Article 45.2? And could it be that the drafters of the Constitution then were mistaken in the wording they have used in 2 because they have in effect discriminated? And further still, whether then the Constitution on its face is wrong and discriminatory. Now, to the question you've asked whether what I would do if I had two same-sex individuals seeking permission to get married to each other. To the extent to which there exists that clause 45.2 saying the limit of people who can marry each other of opposite sex, I would say it is not possible. However, Commissioner, it is an issue I've looked at because I had, in my previous life, I had been asked to consider an argument on this. I have sometimes wondered, Commissioners, whether Article 45 can be read to represent two scenarios. The first scenario is that one limited only to paragraph 45.2, being two adults needing to marry, in contradistinction from a situation where the heading of that Article 45 is headed family. And then one says family is the natural and fundamental unit of society. Whether it is possible to deny permission for marriage, but the Constitution inherently acknowledges that you can have a family of same sex. That would be my contention, that for purposes of marriage, probably as a judge, I would say the law is clearly prohibitive. But then I would wonder then whether the law seemingly at clause 40, so the only exclusion is 45.2. 45.1, 1 and 3 and 4 seem to accommodate existence of a family. And so if it is possible to argue that there is a difference between a marriage and a family, then it should be possible also to say that there is almost a permissive extent to which the Constitution allows a family constituted of people of same gender. Of course, I'm very much alive that I am a candidate. I know it's a very unpopular argument, but I'm just making it as a legal argument. I'm not making it as a question of my position. I need to clarify that. The second limb of your question was whether then you could say that Article 16 of the Convention on Women's Rights, I am not very familiar with that convention, whether that Article 16 is one of those unenumerated rights. I think the Article 19 that you had invited me to was very explicit that they are tenable to the extent to which they are not inconsistent with the Constitution. So if the question was whether or not they can get married, I would say it is not one of those rights that are protected. But if the argument is that we want to be recognized as a family, then I think the matrix of the issue would be completely different. Probably then there would be an argument around it, Commissioner.
Okay.
The question was very long. I have tried as much as possible to answer it. I don't know if I've answered it.
Yes, yes. So I tried to set the context because there are sometimes there are hard questions that are presented before the court and that the court should answer. Now I want you to take to Article 49 on freedom and security of a person.
Yes.
So Article 49 provides that every person has the right to freedom and security of the person, which includes the right not to be, and for purposes of my question, is D, subjected to torture in any manner, whether physical or psychological. So, physical torture is fairly, something, it's discernible.
Yes.
But psychological torture might not be, immediately discernible. So you have, and this possibly we practice it when we were younger, where we were, as children, we did not have a choice to the oath of allegiance. I pledge my allegiance to the President and the Republic of Kenya. You remember that?
Yes.
Or salutation of the flag.
Yes.
Now, would you say that forcing children, to do oaths of allegiance or to salute to the flag, without having the choice on participating in those activities, would amount to being subjected to torture, whether physical or psychological? Because it's not a choice that you have, particularly if you're in school. I don't know whether it happens right now, where you are told, salute to the flag, or it's at 6 p.m. the flag is about to be lowered. Stand up and be at attention, or do the loyalty pledge.
Okay, so can I answer?
Yes.
Yes, my answer would be, I understand your question to be particularly in respect to the flag. You didn't say what flag, but I assume it would be the national flag.
Yes.
You also said pledge. I assume it is pledged to the country rather than to an individual or to any religion. To the extent, therefore, that you are dealing with national symbols and national concern, I would think it is more of patriotism than a question of torture. That's one. Number two, I would say, since your question is very carefully cross-referenced with children, that children being people who are being molded, it is right that they should be subjected to develop a sense of patriotism and loyalty, and I wouldn't see anything wrong in subjecting the children to appreciate the importance of patriotism and loyalty as they grow. And lastly, you tie your question with the question of torture, both physical and psychological. My understanding would be that torture is a relevant part if you intend to extract something out of it. In the situation of the children, I think it's just teaching them where priority, where importance, where values exist. It wouldn't seem to me like anything is being extorted out of the children. They are not being asked to make any confession. They are not being asked to sign off any rights. They are not being asked to surrender anything or to give anything. And to the extent, therefore, that it is part of education and development of the children, I would contend that it is a legitimate conduct.
Okay. And lastly, if you look at Section 3 of the Supreme Court Act, provides for the object of the Act and makes further provisions with respect to the operation of the Supreme Court and its final judicial authority. And one of the guiding principles under 3 is that the court should develop rich jurisprudence that respects Kenyan history traditions and facilitates its socio-economic and political growth. Are you aware of instances whereby either the Supreme Court has developed the common law or it has infused these constitutional principles and created sort of a Kenyan context interpretation of the law? And I get this from what Justice Mutunga used to say, that we should develop jurisprudence that is indigenous.
Okay, so I will answer the question in terms of what indigenous jurisprudence and principles of law have been developed by Kenya, and with reference to your question, particularly by the Supreme Court. I think in the recent past, the Supreme Court has made a determination on the question of matrimonial property. And in it, I think it is an indigenous contention that contribution for purposes of the rights of a spouse can be gauged, not limitedly to financial contribution. It could very well be in kind, family upkeep, taking care of the children. And I think that's an indigenous contention, that contribution is not limited to financial contribution. I think that one. The other one, although I can't say for us absolutely that it is, it has been determined by the Supreme Court, I think is the issue of trust on land. Being that where you have a family member being registered in the course of adjudication and other types of registration, being registered as the owner of the land, it shouldn't be perceived as if that is the only owner of the land. It should be treated as a trust on behalf of the family, on behalf of the other family members, and that it is being held by the person whose name is registered in trust for the rest. The other one is probably also trust in relation to matrimonial property, that where you have one spouse's name.
All right, thank you. All right, thank you, CJ, that's all.
Thank you.
Thank you very much.
For example, or for instance, there is a pervasive understanding of what constitutes public interest. And rarely do courts differ on what constitutes public interest. But we cannot say the same of general public importance. So as you answer, you may kindly also tell us whether there is a difference between public interest and general public importance, and whether or not there is a need for jurisprudential coherence and guidance on the same.